is owned, none of that is owned by the company unless there's a writing to the contrary, all right? So in that respect, we'll talk about creating some documents that will transfer those rights to your company and how to do that, knowing that secret that person holds. Original mental impressions are really the first step in inventorship. And so inventorship is 2 steps, okay? You have the original mental impression from the inventor, and then they have to reduce that mental impression down to some practice, whether it's constructive practice on paper or actual prototypic practice, actual reduction of practice. Again, the ownership of that mental impression, or the inventor, is the person who owns that patent right until it's assigned to the company or to some other individual or business entity, okay? And I think that that's important. I think that many clients believe that they do own these mental impressions of their employees or their contractors. And very often they say they're relying on a work made for hire, and we'll discuss that a little bit later, okay? So authorships are also interesting. So this is a copyright right, works of authorship. The moment you produce some creative expression and reduce it down to a tangible form, whether that's on paper or maybe it's on a computer disk or in your hard drive. So there you have a copyright. You don't have to wait for it to register it because it arose automatically, you know? You actually own this copyright from the moment that you actually reduce your creative expression down into tangible form, okay? Again, however, it is the author that owns the copyright rights in works of authorship unless there's a writing to the contrary, okay? And this is a pretty broad area. I mean, it can be sound recordings, text, drawings, pictures, photographs, designs, music, sculpture, architectural work, digital data, media, computer code. And I would say that the computer code and I'd say that books are a good example of where people run into problems. I have a couple of clients a year that come in and say that they wrote a book and they had a friend drew the images or the photographs or took the photographs for the book. And they've been making good revenue off of it until the other party called them on the phone and said, well, you know, I was an author of the images and you owe me half the revenue stream in the copyrighted work. That's because if you have somebody who writes the text and you have somebody who does the images or does the drawings, you're joint authors. And unless there's a writing to the contrary, it's a joint copyright ownership. And under US law, revenue generated off from a joint authorship is divided equally amongst the copyright owners. Okay. Information that does not qualify as authorship. So you're using that in association with maybe a service that you're providing or a product you're selling. It might include scents if you're selling perfume. It might include sounds if you're Harley Davidson and you are concerned about the sound that your motorcycle is making. Could be words, could be phrases, symbols, designs, names, taglines. So we're talking about trademarks here, okay? So I think interestingly about trademarks, and I think people don't recognize this, is that the trademark arises through use, okay? And it's the party that uses the trademark that actually owns the rights in the trademark initially. And so if you are a band and you're playing music at certain destinations and you're using a band name, then you have a general partnership, but the partnership owns the trademark. And because it's a general partnership, that trademark, everybody has the right to use that trademark right because it's owned by the band, okay? As an example. Also, the commercial look and feel of items. We're talking about designs and trade practice. So you can actually trademark the look of something. So for example, you remember Denny's restaurant? They used to have you'd walk in and they had these brightly colored orange and pink seating. So they actually hold a trade dress in that appearance and the look of their architectural building as well. So who owns all the information is very, very important. And I think that the big impression I'm trying to leave you with is that most people do not know who owns the intellectual property that the company, of the company information that the company is in possession of. Okay. So obtaining the ownership of the information. Okay, so here are the important points for companies. And I don't know how many of you, maybe you can raise your hands. How many of you have companies that have employees? I don't know. So very often a company will have a employee handbook, okay? And we have one, and most companies that have many employees have a employee handbook, okay? And I think that the big mistake that people make with the employee handbooks is they assume that because an employee is signed the handbook, that they own everything that that employee creates on behalf of the company. And so very often these employee handbooks have a reservation that I've had one where I litigated a case about 5 years ago, and the employee handbook said, we reserve the right to make changes at any time without notice and interpret those policies and procedures at the discretion of the company, okay? So, so in the middle of the litigation, the judge actually said, well, you know, that handbook is an illusory promise. And you can't, it's not a valid contract. And so the employee signing that copy of the handbook hasn't transferred anything to the company because it's an illusory promise. If you can just change the merits of the promissory terms and conditions at any time without having them re-sign it, okay? So if you have an employee handbook, you should check it for that illusory promise. And actually then instead of doing that, actually create an intellectual property assignment, okay? So what we would suggest for employees that are within your LLC or your corporation, you should have a separate agreement with them. And the separate agreement would have a confidentiality statement, a non-compete statement, an invention agreement that basically says in present tense terms that I hereby assign all right, title, and interest in all of my innovations and authorships to the company, okay? And it can't actually be, can't actually just say I will assign, or I might assign, or I'll assign at some time in the future. It has to actually be a present tense assignment that says I hereby assign to you, the company, all right, title, and interest in my works of authorship, my inventions, intangible conceptions. And then, of course, then the company then does own the intellectual property that would be the trade secrets, the inventive aspects, the authorships, and the trademarks that that person might be using at that point. Okay. Normally I would ask if there's any questions about ownership at that point, but please reserve those until the end and I'd be glad to answer them, okay? The other problem that I find that companies run into is the disclosure of information to others, okay? So this is incredibly important in terms of sharing secrets or sharing inventive concepts with others, okay? So I don't know how many of you, I know that Will has some patents. I don't know how many other people have patents in this group. Raju, you have a patent. I think that there is a misconception, I think that attorneys give their clients that, you know, you can hold something in the public domain in the US for a year, and in that grace period, you can still file a patent application, okay? I think that that's incredibly poor advice. I know that many attorneys give that advice, but here's the problem with that. First, by sharing the information, if it's a trade secret, it's no longer a trade secret at that point, okay? I mean, obviously a trade secret is something that you maintain secrecy of, and we'll talk about that a little bit later. But also in terms of your initial mental impressions about inventions, if you put those into the public domain, you may be protected in the States through its 1-year grace period. Japan has a 6-month grace period. South Africa has a grace period. Canada has a grace period for some items. But I will tell you that worldwide, we are the exception and not the rule. The rule is that if you put information into the public domain, whether that means you put it on your website, you convey that information to others, you offer it for sale, or you sell it publicly before you file your patent application, you will probably have lost all your foreign rights in that innovation at that point, okay? So my rule of thumb is that if you're going to file a patent application, be very certain that you actually don't disclose the information into the public domain before you file the patent application, all right? And I think that this is an interesting process, especially in terms of the filing statutes in the US. We actually were a first to invent country, but that switched to a first to file country. In other words, the first person to get to the patent office is the party that owns the right to have the patent prosecuted. You can imagine that, say you have the grace period, you're in that grace period and you're relying upon it, and you'll have some attorneys who'll tell you, well, put it on your website, put your innovation into the website, therefore you'll have it in the public domain, and then you can wait a year to file your patent application. But I will tell you that what I have seen happens is that when you put a really nice revenue generating product into the marketplace or an idea, somebody's going to pick that up and they're going to be the first to file, okay? You may argue that you were the first to invent and that it was in the public domain, but you know, you would have to go through the formalities of the USPTO to prove up your first to invent status and that you published prior to the time that they filed their invention. And you can accomplish that, but it's going to be very time consuming and it's going to be a very expensive process. Not so much in terms of filing costs to file the petition, but to actually prove up your inventorship and to prove up your first ownership is going to be a very expensive event. And the last time I did one, it ran the client about $30,000 to get through the process, okay? So take this away. Do not depend on the US grace period or the grace period in the Philippines or Canada or Estonia, Japan, South Korea, Malaysia, Mexico, and Peru. Simply do what's right. Get with your patent attorney early in the development and make a decision about what your strategy is to both file the application and to avoid the problem where you might end up actually running over the grace period or having somebody beat you to the patent. Okay. Okay. So you might be asking the question, well, you know, that's fine, but I put my information into a confidential disclosure. And all of my communications have been confidential with respect to the party I'm in confidence with, okay? So in that respect, the problem with that is that if you were to enter into a confidential relationship and you disclose your trade secrets to that party in your confidential disclosure and disclosure agreement, the problem you're going to run into is that in the US, we do not have a trade secret doctrine. You know, so the fact that you may have offered to sell something in confidence to a party does not prevent you from running the 1-year statute for an offer for sale. It still is treated as a public disclosure. And quite a number of my clients have run this problem where they offered to sell a product under a non-disclosure agreement and then found out that they waited more than a year to file their patent application. And did the examiner care? No. Did the patent office care? No. Who's going to care? The person's going to care is when somebody wants to wants to invalidate your patent rights, and they just depose you in a deposition. They find out that in fact you made the offer for sale under a confidential circumstance, and then waited more than a year, and they'll invalidate your patent right. Okay, so be cautious. Okay, the trade secrets. So assuming that you do obtain the assignment from your employee or the contractor to own the trade secret. It's not a trade secret unless you actually take efforts to conceal it from others, okay? So what does that mean? I mean, the Coca-Cola formula has been a trade secret for 100 years. It's locked in a vault somewhere. So only certain people have access to the formula. So that's a reasonable effort to conceal the information from the public. For companies that are small companies, your lockbox or your vault is really your server and the permissions to access the content on your server. So if you have a trade secret, maybe it is a formula to make a product, or maybe it is a method of making a product, or other trade secret information. What you need to do is you need to set your permissions to only a very select few of people, and when they use that permission, it's date coded for access entry into that lockbox or into the server in the time that they got out of your server, okay? And the information that they took out of the server, okay? So that would be certainly a reasonable effort to conceal the information if you want to maintain the trade secret. And trade secrets become part of your intellectual property. And when you're trying to sell your company or to investors or to sell your business, those trade secrets may have more value than the rest of your company. I mean, the Coca-Cola formula is worth more than all of their distribution plants worldwide. It has a greater value than all of their tangible assets, okay? This slide just simply reaffirms the Supreme Court's decision about that any sale or an offer to sell an invention, whether made in public or in secret, may fall under the on-sale bar and could prevent an inventor from obtaining a patent that the invention resulted in a patent being subsequently invalidated. So this just is a Supreme Court decision. If you thought that I was incorrect in my statement, there's the Supreme Court case you can rely on. This does occur quite often. I've had it does come up in my practice maybe 4 or 5 times a year. And I'll tell you that it's very hard, very, very difficult to paper around or paper over an offer for sale or a sale in secret that's done more than 1 year before you file your patent application. Okay. So non-disclosure agreements. I'm sure that all of you use non-disclosure agreements within your companies, okay? There are 2 flavors. One is a unilateral non-disclosure agreement. That means that I give to you secret information, and I don't expect to get any secret information back from you. This is important because why would you enter into an obligation to hold another party's information confidential or secret when you're not expecting to get any? All you're doing is opening the door for them to come back years later and assert that they gave you confidential information that you never received and to create a suit over it, okay? So use the unilateral non-disclosure agreement when you can, where it just simply says that I give you confidential information, but I don't want anything back, okay? The second flavor, of course, is the mutual non-disclosure. That's what we see most people use. And of course, in that case, your intention is that you're going to give them secret information, but you intend to get back some confidential information of theirs so that you can progress the development of your relationship together further, okay? But use the unilateral information, use the unilateral agreement whenever possible, okay? Here's a big concern that we run into quite often with non-disclosure agreements. I actually ran into this just recently, and so it's a long-term but an ongoing problem. And I will tell you that the most recent concern that raised this issue was I had a client who depended upon ChatGPT to create a non-disclosure agreement for him, okay? And and he took that ChatGPT generated non-disclosure agreement and had two other people sign it, okay? And then that party went to a large company and made an offer to buy some intellectual property from that company. And in the process, it turned out that the other two parties to that non-disclosure agreement indicated that they didn't have any funds and couldn't help them move or advance the position forward. And so my client said, well, that's fine, then I'm just going to do this on my own, okay? And you guys are held to this non-disclosure agreement because it's a contract and you're not going to disclose any information. And as it turned out, one of the partners to that agreement went behind the other party's back, and I had written the buy-sell agreement for that intellectual property. And the other party to that non-disclosure agreement went to the company and made a secondary offer, okay? And the company said, well, if there's going to be a disagreement with the buyer, we don't want to get into this at all, and so they actually created the deal, okay? So my client said, well, I had this non-disclosure agreement, and so I would like to sue this breaching party because he cost me $100,000. And I said, well, let me have the non-disclosure agreement. It turns out that he didn't have a non-disclosure agreement that listed these exclusions to confidential information, okay? So the federal and state statutes require you to list in your non-disclosure agreement exclusions to confidential information. And if they're not listed almost exactly as I have them written in this slide, that produces an invalid confidentiality agreement. And so the other party that went ahead and tried to work around my client said, well, it's an invalid NDA because it doesn't have the exclusions in it. And so the carry-away message is to make certain that, first of all, that you have a valid non-disclosure agreement, okay? And I find that many, many documents that I review do not have these exclusions. And in this case, that other party actually did defend themselves by saying, well, they didn't have the exclusions, so I wasn't in breach of the agreement because it was an invalid document, okay? Second, I think that most non-disclosure agreements that I read do not include a promise not to compete, okay? So it's nice to have a non-disclosure agreement, but I will tell you that if you're generating a lot of revenue with a product, or you think that the idea is going to generate a lot of revenue, do you think that the other party is actually going to keep his promise to you? My experience is that they do not, okay? They simply say, well, we had ideas too, and so we're just going to compete head-to-head with you, and we're going to breach the agreement and sue us if you want to, And if there's not a promise not to compete, they have a pretty good position, actually. The other aspect is that most non-disclosure agreements don't indicate that there's no implied rights. In other words, the document doesn't say, I'm giving you this information, but you don't own it, only I own it. And we're not going to convince, by not saying that there's no implied rights, it tells the other party in bright terms that they don't have a license to use the information and they don't have a right in ownership in the information, whether or not you have ownership of that information or not in your company. Okay? Then the biggest concern, and this happens, I would say, in 80% of non-disclosure agreements I read that clients bring to me, there's no promise to assign improvements in the technology back to the company, okay? This is incredibly important. So you're in a meeting and you say to the party, to maybe there's 6 people in the meeting, and you say, I've got this great super idea, and it's going to generate billions of dollars. And then you go on and you're describing the invention under confidence, and some person raises their hand and says, wow, it would be a really great invention if only it had these further improvements. Okay? Who do you think owns those improvements at that point? I take you back to the second slide. It will be the party who raised their hand. That individual now owns the improvements in your technology. Okay? Now, he will probably run out and get a patent for the improvements, and probably the improvements make it the most marketable product. Okay? So you should read your non-disclosure agreements word by word and make sure that there is a present tense, I hereby assign back all improvements in the technology based upon the confidential information that I'm giving to you. Okay. Second, trade secrets. Every NDA, and here's the other mistake people make, is they don't make a survival clause in their NDA. So you're providing information over the term of the agreement. And maybe it's a 1-year agreement. And it comes down to the last day of the 1 year, and you disclose information to them on the last day of the NDA. And what happens on the day after that? Now the NDA terminates. And so, I think there's an argument that now the information isn't confidential any longer. And so you should always have a survival clause, especially for your trade secrets. And I usually use a survival clause that says the term of the agreement is 2 years. And also it survives for 5 years from the disclosure of any piece of information within that term period. Okay. So that way you're safe for 5 years. It gives you time to file your patent rights for the improvements and all of those things, and probably actually generate some prospective rights in the patent pending at that point too. Okay. Let's switch to trademarks. Okay. So again, trademarks are created by use in commerce. And I think that a lot of people don't recognize what a trademark is. Okay. So when I talk with clients, let's say, for example, you're using the mark, your company name, let's say it's Firewall Forward, okay? So that's a business entity name. It's not necessarily a trademark, but if you use it properly, it could be a trademark, okay? So I start a company and it's called Firewall Forward. And the company goes on and starts to provide services to repair reciprocal piston engines in airplanes, okay? So I'm doing repairs on everything that's forward of the firewall forward. So I start using that mark in association with the sale of those goods, okay? I have not registered the mark with the USPTO, but do you have a mark at that point? And the answer is yes, because the moment you started using the mark in association with your goods or services, suddenly a trademark right arose automatically for the scope within the geographic scope that you're actually selling those services. So, and if you had a website, for example, that sold products nationally, and you associated your trademark with it, now you have a trademark that has an international presence and footprint, okay? All in common law rights. And you can enforce that through litigation if you want to. The problem that you run into, of course, is proving up that it's really a trademark, okay? But if it's used properly, and I think that the problem people have is they often don't use their trademarks as trademarks. Sure, you can take your common law rights and you can enforce them through litigation at that point. So you haven't spent a dime and you've created a trademark. If you just start to use it properly, and within your geographic area, and you haven't spent a dime doing that, okay? So LL Bean ran into problems with this use issue in terms of the association concern, okay? So you recall that L.L. Bean has a catalog and they sell products and they have L.L. Bean prominently displayed on the front of the catalog. And somebody started using the trademark L.L. Bean with other products. And of course, L.L. Bean sued them. And the court said, well, that's fine, except you don't have a trademark. And L.L. Bean goes, of course we got a trademark. Here it is. We have this catalog and it's got L.L. Bean on the front of the cover. And the court said, well, no, that's not association with the actual products. To get the association with your products, you actually have to have the mark closely associated with the actual products you're selling. And the party had to have the right to buy those products to prove up the fact that it's actually in use to buy a product. So now when you pick up an L.L. Bean catalog, you'll notice that the L.L. Bean catalog has L.L. Bean printed on every single page, and every single page tells you where you can buy the product and the phone number you can buy the product from, okay? That's what you need to do, okay? You need to have that kind of association. So you'd have your product, you'd put your trademark next to it, and you'd have a link to a page that they could actually click on to buy the product. That is enough to set up your common law patent rights or trademark rights. And now you have some intellectual property you thought you did not have. I'd say that the other thing that is interesting too is that if you have a business name that's Firewall Forward and you have a trademark Firewall Forward, if somebody then comes and uses a company name that is very similar, that trademark right will trump their business entity right to use that name, okay? Moreover, if you really want to tidy things up fully, you'll go out and get the domain name, firewallforward.com, okay? Now you've got a trademark, a domain name, and a business entity name, all of them protected by your trademark rights, and you can push the person using the domain name off, and you can push the person using the business entity name off, okay? Okay, so how do you use the trademark? I think that first it has to be a trademark, okay? So when you're looking at your information of your company, okay, and you're looking at your business name, you have to make certain that it actually is a trademark, okay? So you can't get a trademark if you have a descriptive mark. In other words, if I am Kleenex, and we all know what Kleenex is, right? If I want to trademark the name facial tissue, do you think I'm going to get a trademark in facial tissue? Probably not. It's descriptive of the product. So you can't get a trademark in a descriptive term, okay? So it has to be not descriptive. It has to be, doesn't have to be quite as abstract as Kleenex, because who would ever know what Kleenex is associated with unless you're forced to buy facial tissue. And Kleenex actually became such a well-used mark that at one point in time, they were afraid they were going to use the trademark because it was being diluted by so many people calling their facial tissues Kleenex or allowing people to do that. So find a term that is not descriptive of your product. Use it in association with the mark. Use it in capital letters, bold type especially. Italics is nice. Underlining, put it in quotes. Use a stylized format if you wish. Make sure it differs from the surrounding text, and you can drive a Hyundai vehicle, okay? Okay, so Hyundai vehicle. The trademark must be an adjective to the noun, okay? Okay, it cannot be just simply Hyundai. I am Hyundai. It has to be an adjective. It can't be Nescafe, never Nescafe, H&M, never H&M. So use it very consistently. So if you have Nescafe and it's got, you know, the accent aigu in the top, never just simply say Nescafe. If you have H&M, never say H and M. And even worse, I had a client that took the H and put it at one corner of the page and the M at the bottom corner of the page. Not a trademark any longer, okay? And if you're using the mark and it's a common law mark that you have just now discovered that you own, you can use the TM, the superscript TM symbol, perfectly fine. it's a notation, lets everybody know that you own that intellectual property. And by providing notice, I think that is sufficient on which you could sue people, and they won't then defend themselves by saying that they just unintentionally didn't know that they were using the term Hyundai, okay? So if you want to file the mark with the USPTO, okay, that is a process that the USPTO will tell you that you can do it yourself. In my experience, people that do it themselves get a lot less than they deserve to have, okay? Tends to be a narrower mark than they deserve to have to associate with the goods and services. And very often they come to us with problems where they filed it themselves, but they can't prosecute it because the examiner has rejected the mark. And then we have to step in and try and be the fixer for all the problems that were created in the filing itself. And I will tell you that it costs more money to do that than to simply let a good attorney file the application for you, okay? Once it's registered, use the superscript R to indicate that it's registered, okay? And so I think that is good use of your domain name, trademark, and business entity name. All of them have great value if you get them in a trademark, in a position where the trademark can reinforce each of them separately against others at that point. Okay. Copyrights. You all own copyrights. Every single one of you owns copyrights, whether you know it or not, okay? As I described, everything that you put into tangible form, if it has enough creative expression in it, is automatically an original work of art that has a copyright associated with it, okay? And the question really is, do you recognize that you own a copyright and what is a copyright? And so literally anything that you reduce to a tangible form that required any ounce of creative expression in the process of creating it is going to be a copyright. I'm going to raise up something that you're all using now. You're all using ChatGPT, I'm sure, at this point, right? Now, interestingly, if I asked ChatGPT to write a story about three little pigs, then it brings back a great story about a first pig, a second pig, and a third pig, all living in three separate types of houses and a big bad wolf, okay? Now, surprisingly, that is not an authorship, and it is not a copyright in you, okay? And we're running into this quite often at this point, that the copyright at that point is owned by the public. And so when you exercise the use of ChatGPT to create content, just be aware that you don't own that content, the public owns that content, okay? Secondly, if you want to own the content of the story of the three little pigs, you'll be more conscientious about the way you prompt chat, okay? First off, you'll decide to write the story about the three little pigs, and you'll prompt chat very cautiously. You'll prompt it, what is a house made of straw? What is a house made of wood? What is a house made of brick? And what is a wolf, okay? And then you'll write the story, okay? Now you are the author, you have the creative, you're the creative expression, and it is then an authorship, and it is now a copyright, and you own it, okay? So be very cautious with your use with chat. I have run into nothing but problems with people trying to have chat become an attorney, okay? I have already had, in this year, clients lose hundreds of thousands of dollars using chat as an attorney, okay? So just don't do that. Prompt chat cautiously and prompt it in for small increments of information. I use it all the time. It's a wonderful tool. Just be very cautious doing it, okay? The co-authorship issue, I run into this every year, at least once or twice a year. where out of the woodwork, a joint author appears and claims half the revenue stream of my client because, by God, they wrote that one frontispiece for the book, or they wrote the program code, by God, and they never assigned it to the client. So if you are having somebody write program code for you, you're having somebody do photographs for you, you're having somebody write content for you, website content, images for your website, whatever the content is, you better be absolutely positively sure that you have a contract with them that has that present tense assignment back to your company, or I will guarantee you that they will be back talking with you when you're generating revenue at that point, okay? And this is really odd. The co-authorship exists regardless of the relative contribution. This is like a joint bank account. My client puts in $1 million into the joint bank account, and the joint owner of the bank account puts in 1 penny, and next day, suddenly all the funds are gone. Okay? Same way with copyright or authorships. One image will result in an ownership in that client of really 50% of the ownership in all of the revenue stream. Okay? With copyrights. Now you have this common law right, okay, in a copyright. The problem with ownership of copyrights that are not registered with the Copyright Office is that they can't be enforced in the court system. So the Supreme Court made a unanimous decision some time ago, it seems like recently, but I'm sure it was more than 10 years ago, that if you haven't got your copyright registered, you can't enforce it until you actually hold the registration in hand, okay? So first, in that respect, again, copyrights are wonderful because they're inexpensive to own and they're inexpensive to copyright through the office. Again, the Copyright Office makes it seem like you can file your own copyright rights. True enough, the forms are simple. The filing fee is minuscule. You should all do it, okay? And since you own the authorships, now that you have actually got the ownership of it of that program code or of those images from your contractors, now you can go ahead and you can file that copyright and get it registered with the Copyright Office. Again, the problem we see is that people do this themselves, and they're successful many times, but very often they don't fill out the forms properly, and they don't really have that registration done properly. So now you enlist your attorney to go and sue the party that's infringing. And the problem is that when the court system looks at it carefully, they realize that there's no registration, okay? But you've already spent $20,000 or $30,000 with your attorney to bring the case, but now your case is stayed, and it's not going to move forward at all until you get the registration in hand at that point, okay? And that can take some time. The Copyright Office is very far behind, and sometimes it takes 6 months or a year to get the registration done, okay? Always use, once you are the author, once you know that you own the copyright, please do use the copyright notice on your website or on your other documents that have content in it you'd like to make notice of your copyright rights. Use the Circle C. You can use it, use the Circle C, put the year after it, and then put your company name, and then put all rights reserved, okay? So people always ask, what does it mean, that all rights reserved statement, okay? Well, you don't have to include that in this country, but in most foreign countries, if you want to extend that copyright right into foreign countries, they'll want to see the all rights reserved language, okay? I think that the copyrights are a very significant asset to own. And the biggest problem for people to wrap their head around with copyright rights is not text or images or photos, but it really is programming, okay? So in copyrights in program code, okay, if you have multiple versions of the code, okay, say you write a first iteration of the code, and then a year later you come back and do an improvement to the code, and the year after that you do another improvement to the code, and then by God you say, oh my gosh, I better copyright this code. What is it that you should be copywriting at that point? Okay, once you own it and you have the assignment of it. The answer is that most people think that all they've got to do is file a copyright registration for the code in its entirety, and that is not true. So if you do that, what you'll own is you'll own a copyright in the most recent version of the code. That is the most recent improvement in the programming code. To do copyright properly for programming code, what you really have to do is you have to go back to the very base item, the very base program code. Copyright that, and then copyright the secondary improvement and the third, all separately, and keep on copywriting the improvements as they occur. Okay, so you're building upon the original copyright with derivative rights. Okay, and if you don't do that, very often what happens, somebody will infringe your computer code, but the problem is going to be that you don't actually own a registration in all the code that they're infringing, but you only own the last derivative work. Okay. We are at 5 minutes before 1. I think maybe I'll stop and take questions, and we'll move the rest of the presentation into session 2. And that will include how do you own patent rights, right? Primarily about patent rights, competition, and then sort of an omnibus question and answer session. And at that point, you can bring me some of your documents and I'll look at them. And we take a look at some of the examples that you bring me, and we'll actually sort of decide whether the documents are suitable for your use at that point as well. Okay. All right. Questions? And Ravi, I don't have a sidebar that says that people are texting. So, okay. That is a great question. Costs are a big issue for startups, how to reduce, okay? So in this presentation, Chris, almost everything that I brought to your attention is almost cost-free. You know, creating trade secrets is free as long as you have an assignment from the trade secret holder, okay? Owning copyrighted work is essentially free as long as you own it and have a document that transfers it to you. And let me express another concern about copyrights and works made for hire. The work made for hire doctrine is about employee use, okay? So if you have your assignment says you're going to assign all works made for hire to the company, that's fine for employees, but that does not work for contractors, okay? Works made for hire is a very narrow right to only certain kinds of works under US 17, okay? It only includes compilations like encyclopedias and the like. So do not expect to gain any copyright rights or assignment if you use the work made for hire language in your contracts with contractors. So the copyrights came to you almost essentially for nothing. Really, this whole presentation is about identifying within the information that you already hold in your company, that information that you can convert into intellectual property rights simply by saying that they are and using them properly, okay? And I welcome you to come to the firm and work on a strategy for developing those basic rights. and kind of catching up because people get far behind on developing IP rights that are valuable assets. Okay. Is there a question about enforcement that came up?
Yes, so enforcement of patents has not been addressed. It is not possible in some places, we are told. Please address patent value in light of competition with China and others.
Okay. Well, that would be part of session 2. Okay. And it is a very important question, but I'm going to answer it anyway. Okay, Ravi? First,
Thanks.
okay. I have an international practice. Okay. I have over 1,250 clients. About half of those are foreign companies. Okay. Almost half of my clients sell products that are produced in China. Okay. I don't know who has told you that international rights can't be enforced. That is completely not true. Okay, so you have to walk away from this session knowing that is simply not true. And then number 2, carrying on or furthering that, I think that most people here, well, don't file a patent into China because you won't be able to enforce in China. That is probably the biggest misconception of all times. Okay, totally wrong, completely incorrect. Novice. Okay. The patent process in China is a very robust process. China, you have to recognize that people say it's not enforceable in China because they don't understand the Chinese and they don't understand the Chinese culture. You have to understand that the laws of countries evolve out of culture, and the Chinese are no exception to that. China is an authoritarian government, and they control everything. Okay, and so you think that, well, what advantage does that give me? I will tell you the advantage that gives you. The Chinese Intellectual Property Office, they have 13 offices in China. Okay, and if I file a patent in China, I can file it as both a utility model, which is good for 10 years, and I can file it as an invention application, which has got a 20-year life. Now, here's what most attorneys don't know, is that you can't go, even if you had an international patent application, like Patent Cooperation Treaty, if you file that PCT application first, you cannot get a utility model in China, okay? What you really want to do is go through the Paris Convention and simultaneously file a utility model and simultaneously on the same day, your invention application. Why do we do that? Because you will hold the utility model in hand within a year, probably 6 months, okay? Now, with that patent right in hand, I can go to China. I can get a notary in China, which is not the same as a notary in this country. A notary in China is a person who is authorized to go and collect evidence of infringement with you. So they go onto the website, they collect up evidence of the infringing party's product, they compare it to your patent right, your utility model. You walk, of course, you're not going to walk. Your attorney in China is going to walk to the patent office in China, one of the 13 offices. The notary is going to show that patent office the evidence of infringement, and that without going to court, that patent office can go and they can close that company down. They simply will force their way through the doors. They will take all the financial records, they'll take all of the inventory, they'll take all the person's cash and leave that person with nothing. How important is it to have a Chinese patent right? Pretty damn important, okay? It's a tremendous deterrent to the Chinese to knock off people on Amazon. Okay, then you can allow your invention application to incubate, get the patent right in that. And if you really want to go to court in China, they have a wonderful system. Okay, you file your complaint with the court in China. You'll walk into a room and there'll be 3 judges. And the notary will produce all the evidence for the judges. You will not say a word. the judges will look over all of your evidence, compare it to your patent rights. They will leave the room and they will come back with a judgment, and 4 hours later, with no other litigation or expense, you'll get their judgment. Okay? How important is that? It's amazing, okay? I had a litigation in Canada from a Chinese company, and I won that litigation in Canada. And it was at my expense. I found out that I could not enforce that judgment in China because I did not have a Chinese patent. I would have had to go and relitigate the entire item in China, okay? So, very important, I think, to not listen to ChatGPT. Do not listen to attorneys that are naysayers. You need to find somebody who's been doing it and has a little gray hair, you know? Then you're in better shape. Other questions?
There's another one. What is the scope of assignment of an employee's ideas if those ideas are unrelated to my current business domain and derived outside work context? And I think this probably needs to be the last question.
Okay, good question. Okay, this goes to what are you having your employee assigned to the company so that you can own the technology that they're developing, okay? So the good document would say, I hereby assign all right, title, interest in all innovations, concepts, copyrights, trade secrets to the company. The scope of that assignment can be as broad as you'd like it to be, okay? Okay, so I would make it as the breadth for everything, you know? As long as it's based upon anything that the company is doing for the company, I think the company should own it. There should be a schedule. If the employee is claiming that he's developed items and he's concerned about that, then there ought to be a schedule and where the employee lists all of the innovations that he is separately or is going to separately develop, so that you can have a discussion about that before you get too far down the path with that employee. So it's not unusual for employees to think that they own all the innovation that they might think of, as long as they're doing it at home or in their basement. But really, it's the language of the contract has to be, is it business related to any commerce that the business is doing or will be doing in the future. And then do the carve out as the schedule on the end of the agreement. Any other questions, Ravi? I'm here.
I think that's all.
Okay, guys, it's been a pleasure. I always get excited about this. I really like to think that you walked away with some intellectual property that you didn't know you had. And again, if you'd like to come over and meet with me, I'm just a mile away on 405 Mason Court, Cherry and College. I own the building and own the company, and be glad to sit with you and chat for an hour at no cost, okay? Catch up with you. My pleasure to meet with you guys.
Thank you all for coming.
Thanks,
Bye.
Robbie. Appreciate the good introduction. Thank you, everybody.